So there have been communications with Mr. Shankman, the attorney that sent this letter. We had received the demand letter on August 29th. On August 11th, I wrote a letter to Mr. Shankman. I requested an extension on the time limits to January for us to adopt the notice of intent, and July to adopt the ordinance approving district maps. Now let me digress from the slide for just a moment. The decision of the City Council this evening on whether or not to change to districts or not is one of the most important, if not the most important decision the City Council will ever make. You would be deciding, if you switch to districts, to change the method by which City Council members are elected. It is a very significant decision, and it is one that should be made with the proper amount of time and effort to review it, which is why we requested the additional time from Mr. Shankman. So on October 22nd of 2018, I get an email from Mr. Shankman. He rejects our request for an extension of time. He doesn't suggest any alternative times. And then on November 1, after a phone call from Andrea Alicorn, who works with Mr. Shankman, they said they would only agree to November 14th for the time for the city to adopt the notice. That was 8 days after the November 6th election. It was before the new council was seated, so that was their timeline on when they wanted that notice to be adopted, without giving this council, as presently constituted, the opportunity to weigh in on whether or not to adopt a resolution. So November 8th, I sent a letter to Mr. Shankman. I said, well, we'll move up the January 23rd date, which is what we had originally proposed, to January 9th for the council to take this action, and then we'll adopt our maps by July of 2019 if the council elects to go this way. Now, I should pause again to make this point. The fact of the matter is that nothing that was happening with regards to Mr. Shankman was going to impact the November 2018 election. We are talking about the November 2020 election. So the fact that we would be making a decision on this tonight for the resolution of intent and adopting and then drawing up maps and adopting an ordinance to approve the maps by July of 2019 would be plenty of time in advance of the 2020 election. I pointed that out to Mr. Shankman in my letter, of course. Then on November 14th, I presented to the City Council an agenda report with regards to the CVRA, and the direction from the council at that time was to come back to the council on July 9th, 2019 regarding the results of my research on the applicable law of the Voting Rights Act and the options that are available to the city. On December 5th of 2018, as I mentioned earlier, we had our 3 council members elected, sworn in, Charlotte Craven, Sean Mulchay, and Susan Santangelo. On December 14th, I sent an email to Mr. Shankman. Since his original letter didn't present evidence in support of the claims he was making in the letter, I sent him an email, and in my email I pointed out that I was asking that he provide us with the evidence in support of those allegations in his letter, that the voting in Camarillo was racially polarized, that it resulted in minority vote dilution, and his other allegations. I requested that evidence so that it could be considered in this agenda report, which I am preparing for you tonight. Mr. Shankman did not provide us with the evidence. Instead, he filed a lawsuit, and he did that on Christmas Eve, which, besides being the day before Christmas, it's also my birthday. And what he did was he files this complaint with the court. It is exhibit, too much lawyering here. It is attached to your agenda packet and as attachment 8. And the plaintiff in that case is the Southwest Voter Registration Education Project, who he had said he was writing that letter from August on, and the defendant is the city. The complaint and summons were served on the city on December 26th of 2018, and our responsive pleading to that complaint is due on January 25th of 2019. All right. Now, let's talk about the history of the California Voting Rights Act and challenge letters, which is what this letter from Mr. Schenkman is. So over the past 2 years, over 40 California cities that had conducted their city council elections by means of an at-large election, such as you have in Camarillo, have received letters threatening to sue their city for alleged violations of the CVRA unless those cities voluntarily transition to a district-based system. I should mention that previously I went through the statute that was in the CVRA and the Elections Code sections. Statutes are often interpreted by the courts of appeal to provide guidance as to what the meaning is of that statute. They interpret the statute, and when those courts make decisions, they serve as legal precedent that can then be used by parties to determine what their rights and obligations are under statutes. Well, with the CVRA, there have only been 3 Court of Appeal decisions that have been made by the courts. They are the Sanchez case, the Ray case, and the Jiraki case. I'm not sure if I pronounced that right.